Imagine winning a really hard-fought legal battle. You get your rightful compensation, but then you watch your employer appeal that decision for years and years. After all that, could you then turn around and claim you're owed even more, years after you were first paid? Does a final court victory truly close the door? Or can the pursuit of justice somehow reopen a case already settled? That's the fascinating tension we're diving into today. Welcome to the deep dive, where we cut through complex information, pull out the most important insights, and help you get well informed fast.
And today, we're doing a deep dive into a really interesting Supreme Court case from the Philippines. It tackles these exact questions: the finality of judgments, those tricky procedural rules, and, the ongoing quest for just compensation in labor disputes.
We're specifically talking about the case of Casilida D. Tan and/or CNL lending investor petitioners versus Luzvilla b. Dagpin, respondent.
That's the one. Officially known as GR No 212111, and it was decided on January 15, 2020.
Okay, let's unpack this right from the start. The story centers on Mrs. Luzvilla b. Dagpin and her former employer, Casilida D. Tan and CNL lending investor. So the initial ruling, way back on September 12, 2003, came from the labor arbiter. What did that first decision say?
Right. That initial ruling was, a clear win for Ms. Dagpin. The labor arbiter found the employer liable for illegal dismissal and awarded her quite a bit in monetary claims, things like separation pay, back wages, service incentive leave pay, 13th month pay, even moral and exemplary damages, plus attorney's fees. Pretty comprehensive.
So a really strong start for Ms. Dagpin there. But as we know, legal fights rarely end with just the first decision. What did the employer do next?
Predictably, the employer's TAN and CNL lending investor, they appealed to the National Labor Relations Commission, the NLRC. But their appeal hit a roadblock pretty quickly. On July 29, 2004, it was dismissed.
Dismissed? Why?
It was a technicality, actually, a crucial one. They failed to attach the required certification of non-forum shopping.
The certification of non-forum shopping. Maybe quickly explain what that is for folks listening. Why is it so important?
Sure. It's basically a sworn statement you have to include saying you haven't filed the same case or similar issues in other courts, trying to, shop for a judge who might rule your way. It's fundamental. Stops people clogging up the system, missing it. That's a big deal. And here, it meant their appeal was dead on arrival, and their motion to reconsider didn't work either.
So with that NLRC appeal thrown out, that ruling became final then. That must have felt like a major victory lap for Ms. Dagpin.
Oh, absolutely. A huge moment. An entry of judgment was issued on January 17, 2005 for that NLRC resolution. That made it truly final and, importantly, executory.
Executory meaning she could actually get paid now.
Exactly. Time to collect. She acted fast, too. Filed a motion to admit computation and issuance of writ of execution on March 29, 2005. She calculated her claims up to that finality date, January 10, 2005. Came out to over 1 million pesos, P1,080,566.66 to be exact.
And did the process to get the money move quickly after that point?
It did, relatively speaking. By May 2005, the Executive Labor Arbiter, the ELA, ordered the release of the employer's cash bond to partially cover it. And then a writ of execution was issued for the rest. Now, this is really key. The writ was fully enforced and satisfied by October 12, 2005.
Fully satisfied, meaning she received the entire amount awarded in that initial judgment.
Correct. Paid in full. Remember that point. It becomes critical later.
But the employers, it seems, they weren't ready to give up, even though the judgment was fully paid. They kept fighting.
They were certainly persistent. They filed a petition for certiorari with the Court of Appeals. Didn't work. The CA dismissed it on October 18, 2007.
So they struck out at the CA. What then?
They went higher, sought relief from the Supreme Court itself through a petition for review on certiorari. But the Supreme Court denied their petition too on June 23, 2008. And that denial became final and executory on August 21, 2008.
Okay, so multiple appeals failed.
Right. And here's the really interesting part, the critical detail. The Supreme Court's denial affirmed the finding of illegal dismissal. So they agreed she was wrongly fired. But crucially, it did not modify the monetary award. The money part, which had already been fully paid out back in 2005, wasn't touched by this final Supreme Court decision.
Okay, so let's recap quickly. Ms. Dagpin was illegally dismissed. She won her case. The award was finalized in early 2005. She received full payment by October 2005. The employer appealed for years, lost those appeals, and the final SC ruling in 2008 confirmed the dismissal but didn't change the already paid award.
You got it. That's the timeline up to late 2008.
So then, here's where it gets kind of tricky, right? In November 2008, after getting paid in full years earlier, Mrs. Dagpin filed another motion for recomputation. That seems bold. What was she arguing?
It definitely raises eyebrows, yeah. It's a question of, well, when does final really mean final? Her argument was this. Since the employers kept appealing all the way to the Supreme Court, the case wasn't truly over until the SE's final say-so on August 21st, 2008. So she argued her back wages and separation pay should have kept accumulating during all those years of appeals right up to that August 2008 date, basically seeking more money for that period between the initial finality and the ultimate finality of the appeals.
Okay, I see the logic, sort of. How did the executive labor arbiter, the ELA, react to this second bite at the apple?
The ELA denied it.
Oh.
On February 19, 2009, they rejected her second motion for recomputation, and the ELA's reasoning hinged on a really important legal principle, estoppel.
Estoppel. Okay, that sounds important. Can you break that down? What does estoppel mean here, and why did the ELA use it?
Absolutely. Estoppel, in simple terms, means the law prevents you from making a claim or asserting a right if your previous actions contradict it, especially if someone else relied on those actions. Here, the ELA said because Mrs. Dagpin had already enforced the original judgment, accepted the full payment calculated up to January 2005, she was estopped, legally barred from turning around later and saying, actually calculated differently, I want more based on that same dismissal. It's about fairness and finality. You can't accept a settlement and then try to reopen it on the same grounds.
Got it. So the ELA basically said, nope, case closed, you accepted the payment based on the first calculation. But Ms. Dagpin, she didn't give up there either.
No, she kept going. She appealed the ELA's denial to the NLRC,
Yeah.
but then she hit another procedural wall.
What happened at the NLRC this time?
The NLRC dismissed her appeal again, but this time for being filed late, out of time.
Late? How? What was the issue with the timing?
It got technical. The NLRC said the 10-day appeal clock started ticking when Ms. Dagpin herself received the ELA's denial order on March 19, 2009. They didn't count it from when her new lawyer, at A, Kenneth Rosal, supposedly got it from her on March 30.
Why the distinction? Don't notices usually go to the lawyer?
Usually, yes, but the NLRC noted her previous lawyer, at 80, Curran, hadn't formally withdrawn, and they argued Addie. Rosal wasn't officially her lawyer of record for that specific order yet. So based on Ms. Dagpin's receipt date, her appeal filed on April 13, 2009 was named 15 days late, past the 10-day limit.
Wow. Okay, so the NLRC said, too late again, but she persisted, right? Took this procedural tangle up to the Court of Appeals.
She did, showing incredible determination. She elevated this very specific issue, whether her appeal was timely, to the Court of Appeals.
And what did the CA decide? Did they agree with the NLRC's strict timeline?
No, the Court of Appeals saw it differently. In its decision on September 24, 2013, the CA actually reversed the NLRC. The CA ruled that serving the ELA's order directly on Ms. Dagpin instead of her lawyer was not proper legal service.
Ah, so the CA focused on the rule about serving the lawyer.
Exactly. They emphasized the rule. When a party has a lawyer, notices must go to the lawyer of record. Service on the client directly doesn't count, legally speaking, for starting the clock. The CA pointed out that even if the old lawyer, at Kieran, had suspended himself, the new one, at Rosal, had formally entered his appearance. And maybe the clincher was the ELA order itself was addressed L. Dagpin Co. Addy, Kenneth P. Rosal. That co-suggested the ELA knew about the new lawyer.
So the CA said the NLRC messed up by dismissing the appeal as late. And they used the phrase compassionate justice, didn't they? That sounds significant. What does that mean in practice?
It is significant. Compassionate justice is where courts recognize that sometimes rigid procedural rules need to bend to avoid a serious injustice. It's not something invoked lightly, because rules provide predictability. But the idea is that technicalities shouldn't completely block someone from having their case heard on the merits, especially if the error wasn't entirely their fault or if the consequence seems disproportionately harsh. So the CA essentially said, given the improper service and the circumstances, dismissing her appeal on timeliness was a grave abuse of discretion. They relaxed the rule.
And did the CA stop there, just saying the appeal was timely, or did they weigh in on the recomputation issue too?
They went further. On the substance of the appeal, the CA actually agreed with Ms. Dagpin about the recomputation. They decreed that recalculating her back wages and separation pay up to that August 21, 2008 date, the final SC resolution date, did not violate the principle of immutability of final judgment.
Really? So the CA ordered the recomputation?
Yes. They ordered it, minus the amount she had already received, plus 12% interest. So a major win for Ms. Dagpin at the CA level on both procedure and substance.
Okay, this brings us finally to the Supreme Court's 2020 decision in GR number 212111. The employers appealed the CA decision, right?
Correct. The employers took it up to the Supreme Court.
So the core issues before the High Court were crystal clear. One, was Mrs. Dagpin's appeal to the NLRC timely filed? And two, the big one, was she actually entitled to that recomputation and increase in her award years after being paid in full?
Precisely. Let's take the procedural issue. First, the timeliness. How did the Supreme Court rule on that? On the procedural point, the Supreme Court agreed with the Court of Appeals. They sided with Ms. Dagpin on the timeliness.
So they upheld the compassionate justice angle, or at least the reasoning about proper service.
They firmly reiterated the rule. Rule 13, Section 2. When a party has an attorney of record, notices must be served on the attorney. Service on the party themselves is just not legally effective to start the clock ticking for appeals. They found the direct service on Ms. Dagpin improper. The fact that the order mentioned Addie, Rawls will reinforce this.
Okay. And did they mention the holidays too?
Yes, they did. They meticulously noted that even if you counted from when Addie, Rawls likely received it from Ms. Dagpin, the subsequent public holidays, Day Valor, Holy Week, legally extended the filing deadline. So her April 13, 2009 filing was, in fact, perfectly within the allowable period. The SC explicitly mentioned relaxing procedural rules to advance substantial justice, supporting the CA's conclusion on this point.
Okay, procedure sorted. Ms. Dagpin wins round one at the Supreme Court. Her appeal was timely, but now, the main event, the money. Was she entitled to a recomputation of the award she got back in 2005?
This is where the Supreme Court's decision diverged sharply from the Court of Appeals. The answer from the High Court was a definitive no. Ms. Dagpin was not entitled to a recomputation or any increase of the monetary award already paid to her.
A clear no. So what does this mean for that principle we discussed, the immutability of final judgments? The SC seems to be drawing a firm line.
A very firm line. The court basically said, yes, immutability matters, especially when a judgment hasn't just become final, but has also been fully executed and satisfied. They acknowledged that, generally, back wages keep running until reinstatement or full payment. But here, the NLRC judgment fixing the amount became final and was fully paid by October 2005. That locked it in.
So the key was the full execution back in 2005.
Exactly. The Supreme Court resolution in 2008 only affirmed the finding of a legal dismissal. It didn't reopen or change the amount of the award that was already settled history.
So even though the employer's appeals dragged on, the financial chapter related to that initial judgment was closed once paid.
That's the essence of it. The court stressed that allowing another execution now for more money based on the same dismissal would violate the principle against unjust enrichment.
Right, getting paid twice for the same period, essentially.
Precisely. You can't benefit unfairly at another's expense. They also explicitly distinguished this case from others where recomputation was allowed. The key difference, those other cases lacked prior full execution. The money hadn't actually been fully paid out yet.
That's a crucial distinction.
Absolutely. And one more point the court made. When Ms. Dagpin received her full separation pay and other benefits back in 2005, that act effectively severed the employer-employee relationship. Once that tie is cut by receiving final benefits, you can't really claim further benefits as if you were still an employee during the appeal period. The relationship was over.
So, wrapping up the SCSC decision, they agreed her appeal was timely filed, procedural win, but ultimately denied her claim for more money, substantive loss, overturning the CA on that point, and reinstating the ELA's original denial of the recomputation.
Correct. A partial grant of the employer's petition, ultimately favoring the employer on the core issue of the additional money claim. It's a real demonstration of how procedural wins don't always translate to substantive ones, and how central the idea of finality, especially executed finality, is.
This case really highlights some fundamental legal doctrines, doesn't it?
It absolutely does. Let's quickly recap those key takeaways for everyone listening. First, the rule on service of notices to counsel. Remember Rule 13, Section 2. If you have a lawyer, notices go to the lawyer. Service on you directly might not count legally for deadlines.
Crucial for keeping track of timelines.
Second, the relaxation of procedural rules for substantial justice. Courts can bend strict rules sometimes, like the CA and SC did on the appeal timing here, if sticking to the rule would cause a major injustice. But it's an exception, not the norm.
The compassionate justice idea.
Third, and central here, the immutability of final judgments. Once a decision is final, and especially once it's fully paid or carried out, executed, it's generally set in stone. It can't usually be changed later, even if errors are discovered.
Provides certainty, but can seem harsh sometimes.
Fourth, the principle against unjust enrichment. Pretty straightforward. The law doesn't let someone profit unfairly at another's expense. No double-dipping on claims already settled.
Makes sense.
And finally, the specifics on computation of back wages and severance of employer-employee relationship. Back wages run until reinstatement or full payment of separation pay. But once that full payment is received, the employment relationship is considered over, limiting further claims as an employee.
So a lot packed into this one case. What really stands out to you from this deep dive? Are you more swayed by the need for flexibility, that compassionate justice approach? Or does the principle of finality, the immutability of judgments, seem more compelling for the stability of the legal system?
It's a tough balance, isn't it? We genuinely love to hear your thoughts on this. Leave your comments below. What did you find most interesting or surprising about this case?
And if you found this deep dive helpful in understanding these complex legal ideas, imagine what else you could learn. Definitely hit that subscribe button for the deep dive. We break down important cases and topics like this regularly, so you won't miss out.
Join us next time as we continue to cut through the noise, sift through the details, and get straight to the insights that really matter.
And here's something to ponder. In a legal system with multiple layers of appeals where cases can stretch on for years, how do we strike that perfect balance between allowing every avenue for seeking justice and the undeniable need for closure, for finality in legal disputes?